US military can't fire HIV-positive soldiers, says judge. The judge makes the final decision. Personnel infected with HIV cannot be discharged from the military. There is no legal basis for dismissing or excluding an HIV-positive member of the US military from the ranks, a federal court in Virginia has said. For those living with HIV, advocates believe this is one of the most significant verdicts in a long time. The Air Force tried to dismiss 2 military members, while the D.C. Army National Guard Sergeant Nick Harrison was refused a post in the Judge Advocate General Corps. Asymptomatic HIV-positive service members with undetectable viral loads are ineligible for global deployment owing to their HIV-positive condition, according to U.S. District Judge Leonie Brinkema's opinion dated April 6. At least one of the most significant decisions in favor of HIV-positive persons in the previous 2 decades, according to plaintiffs' attorney Peter Perkowski. An email requesting comment on the verdict and whether the Defense Department planned to appeal went unanswered. Their pseudonymous names in the 2018 lawsuit stated that advances in therapy imply they may readily get adequate medical care and pose no genuine danger to others. An injunction against the airman's release was maintained by the Richmond-based 4th U.S. Circuit Court of Appeals in 2020. The 3-judge bench ruled the military's reasoning for excluding HIV-positive service personnel from deployment was outdated and contradictory. During the pendency of the appeal, the injunction remained in effect. Because their jobs required him to deploy regularly, and their health prohibited him from going to the U.S. Central Command's area of responsibility, the DOJ contended before the 4th Circuit that the 2 airmen could no longer execute their responsibilities. Personnel with HIV are not allowed to deploy without a waiver from Central Command. When asked about the increased danger on the battlefield, the DOJ agreed that treatment reduces the chance of HIV transmission. At a hearing in 2019, an airman's lawyer claimed that the chances of spreading HIV in battle are so remote that they shouldn't restrict the airman's deployment or cause them to be dismissed. A limitation on deployment may have been justifiable when HIV medication was less successful in managing the virus and reducing the danger of transmission, the 4th Circuit Court said. For the sake of fairness, the judge ordered that her judgment in the case be sealed for 14 days so that both parties may request redactions. The court ordered the Air Force Secretary to reverse his decision to dismiss the 2 pilots, and the Army to reverse its decision to refuse Harrison's application to join the JAG Corps.